just when you thought it was over. We are just getting started. Welcome back. How are you doing today? Happy hump day! It's Wednesday and it is a juicy one. So get your emotional support lip gloss ready. Vanzan, come to the front. Leslie Sloan, come to the front. James Vitusca, let's talk about you and let's get into it. You are in frame with Mandy Magnan. Hump day, Wednesday. Okay, that's it. That's all I got. Just to get started real quick, there is some rumors running around that Blake Lively was not deposed. Although that may be true or may not be true, there is no official reports that Blake Lively was or was not deposed. Nothing. Okay, no official sources, no reports, no nothing that she was. And I think it's coming from the meeting that happened, the conference meeting, which I took very detailed notes about yesterday and made a full video about. And in that meeting, yes, they did talk about depositions being in July, but they only brought up depositions twice in that meeting. And the first one was the judge asking Blake Lively's counsel if they plan to depose these third-party witnesses who are the tag employees, and if they can get the relevant documents from them when they depose them, can they just ask about them? Blake Lively's team said that yes, they are going to depose them, and that will be in July. All of the non-parties and third parties will be in mid-July all the way to August. And then the second time the depositions were brought up was at the very end. Maxwell, who was the counsel for the tag employees, said that he just wants the court to note, and he just wants Judge Lyman to note that although Blake Lively's counsel said that they are going to have depositions in mid-July all the way to August, his clients, the tag employees, have not got any notice of said deposition. So basically calling her a little bit of a liar, pants on fire, but really just saying like, hey, if she already has the dates for all of the non-parties, we didn't get no dates. That was the only two depositions that were mentioned in the conference call with Judge Lyman. None of it had to do with Blake Lively and her deposition. Of course, it had to do with Blake Lively because it's her case, but it didn't have to do with Blake Lively and the deposition that was supposed to be taken by Brian Freeman. Speaking of Brian Freeman, we do have a reply by Brian Freeman about not filing the amended complaint, as well as a reply from Blake Lively's camp. And I think her, honestly, don't come at me. The reply is quite granted, honestly, because everyone was waiting, whether you're on Team Justin or Team Blake or wherever you stand, you're on no side, you just want to know the truth, whatever it is. Everyone was waiting for an amended complaint based off what Brian Freeman had previously said to TMZ. So it was a little bit of a letdown, but not really, because I think things are moving in a completely different direction and they're going to get them. They're going to get them because what's been happening is a little bit juicy. Brian Freeman says, we don't need to refile claims against Blake. There are other ways to win the case. And this is why I think they have something else cooking, because ain't no way, there's no way. What reality are we living in that we actually think that Brian Freeman missed the deadline? They just missed it. Like, that's why I think it was a little bit of a, no, nobody's missing a deadline to refile an amended complaint. So Justin Baldoni's lawyer promised to refile 4 claims against Blake Lively, but he missed the deadline to do so. And now he tells us his client will be pursuing additional legal options against Blake. Brian Freeman, there he is right there. Hey! Freeman is also brushing off the fact that a judge earlier this month threw out Baldoni's lawsuits against Blake, Ryan Reynolds, and the New York Times. Justin's attorney tells us the court's decision on the motion to dismiss has no effect whatsoever on the truth. Preach. We are confident that we will prevail against these factually baseless accusations. And then a rep for Blake said, the court dismissed the frivolous $400 million Baldoni Wayfair lawsuit in its entirety. In the days that followed, Baldoni's lawyer said that the judge's decision to dismiss their case was not a big deal as they promised to amend and refile it. As per usual, that was not true. The court's dismissal of Baldoni's sham lawsuit was a total victory after all. And honestly, kind of a warranted response, because he did come out and say that that was a false victory, et cetera, et cetera, et cetera, that they are 100% going to amend the complaint, and then they didn't. But they are pursuing additional legal options that are available to us. Now, when this maybe came out, people could just be like, oh, that's big lawyer talk. When you don't have to make a statement out there, that's lawyer talk. However, what happened today in the courts, what was submitted in Jones versus Abel, we're gonna get into right now. sorry, but I'm so excited that finally in the court docket, Vanzan lawsuit, SHAM lawsuit is there. Let's go. We'll just quickly go over the declaration made by Elaine Garofalo, who is one of the newest lawyers brought onto the Wayfair team. She has been working with Brian Freeman at Liner Freeman Teltman, I think since the fall of 2024, but she was just brought onto this case not too long ago. And she says, I'm a partner with the law firm Liner Freeman Teltman and Cooley LLP, attorneys of record for defendant and counterclaim Jennifer Abel. I submit this declaration in support to a motion to compel compliance with the document subpoena served on non-party Vanzan Inc. on April 21st. They've had since April. We're in June, end of June. A true and correct copy of the complaint filed in Vanzan versus Doe's 1 through 10, index number. Then they give the index number, September 27th, 2024. The Vanzan action is attached and incorporated as Exhibit B. And a true copy of the December 19th, 2024 notice of discontinuance filed in the Vanzan action is attached and incorporated as Exhibit C. Apart from the complaint and notice of discontinuance, there are no entries on the docket in the Vanzan action, and a judge was neither requested nor assigned before the Vanzan action was discontinued. A true and correct copy of an April 21st, 2025 deadline article in which Blake Lively's counsel from the law firm Manat, Phelps & Phillips LLP and Wilkie Farr & Gallagher LLP acknowledge and defend the Vanzan action and subpoena is attached and incorporated as Exhibit E. My office participated in a series of meet and confer conferences with Vanzan's counsel from the law firm Zuckerman Spader LLP via email and Zoom. During these conferrals, Ms. Abel agreed and withdrew request numbers and then really narrowed the scope. I mean, she cut down so many things to try to get Vanzan and Ryan Reynolds to give them documents. And all she's really looking for is the actual lawsuit, right? But they've refused. Notwithstanding the proposed compromise of the date of the filing, Vanzan has not produced a single document responded to Miss Abel's request. How wild is it that yesterday we're on a call with Judge Lyman because Blake Lively's motioning to compel documents that she never got through subpoenas, but yet they're stonewalling the opposing team as well. It's like the hypocrisy again is loud. And yes, Blake, you and your team and Ryan Reynolds and Stephanie Jones all came out and said everything was Gucci. Everything was fine. What we did was okay. There was nothing wrong with it. It was good lawyering. Show it. Show the documents, girl. This is the motion to compel. Dear Judge Lyman, defendant and counterclaimant Jennifer Abel respectfully moves pursuant to Rule 1C and 4C of Your Honor's individual practices and Rule 45 of the Federal Rules of Civil Procedure for an order compelling the production of documents from non-party Vanzan Inc. in a response to a document subpoena served by Jennifer Abel on April 21st, 2025. Declaration of Elaine S. Garofalo. This motion is brought following the written exchange of emails and a Zoom meeting in which Abel narrowed the subpoena's documents request. However, disputes remains that require the court's attention. Abel's claims against Jonesworks LLC and its principal, Stephanie Jones, collectively Jones, motherfucking Jones, center on the allegations that in August 2024, just prior to Abel's scheduled departure from Jones's employ, Jones seized Abel's cell phone and accessed and downloaded the contents. In anticipation of litigation against Abel and other Wayfair parties, Jones collaborated with Blake Lively to contrive a mechanism for Blake Lively to obtain the data that Jones had pirated from Abel's phone and cloud accounts, including confidential and privileged text messages, which are the centerpiece of this dispute. This was accomplished through a subpoena issued in a sham action captioned Vanzan versus Doe 1 through 10, filed in the New York Supreme Court on September 27, 2024. Abel is informed and believes that Vanzan is a shell company owned or controlled by Lively and/or her husband, Ryan Reynolds. The facts speak for themselves. The Vanzan complaint asserted only a bare-bones breach of contract claim, of factual allegations against 10 defendants who, although parties to an allegedly breached contract with Vanzan, were never named or served. There is no conceivable link between Abel and Vanzan or the unspecified contract that the Doe defendants allegedly breached. In other words, Vanzan had no discernible need for the information Jones obtained from Abel's cell phone. After the Vanzan subpoena's return date, the Vanzan action was dismissed without other proceedings and without ever requesting the assignment of a judge. Shady. The Vanzan subpoena opened the door for Lively to obtain the documents Jones extracted from Abel's phone without notice to Abel or the Wayfarer parties against whom Lively intended to use the information. Lively produced at least some of the information during discovery, confirming that the SHAM Vanzan action was successful in facilitating the transfer of Abel's data to Lively prior to the filing of Lively's claims against Abel and the Wayfarer parties. Lively's lawyers have publicly acknowledged and defended the SHAM Vanzan action and subpoena, declaring that there is nothing untoward here, just conscientious and thorough investigation, and characterizing the Vanzan action and subpoena as common tools that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities. Arguing the ends should justify the means, Lively's lawyers admitted the Vanzan action and subpoena enable them to access Abel's text messages. Such tactics are hardly common or appropriate, whereas here, the lawsuit is a sham. The subpoena is intended to obtain information irrelevant to the proceeding in which it issued, and most egregiously, the purpose of the subpoena was either to obtain privileged and confidential information without notice to Abel, or to cover up Jones's prior disclosure of Abel's confidential and privileged information to Lively before the subpoena was even served. Abel remains in the dark as to whether Jones was actually produced documents in response to the Vanzan subpoena, or whether the Vanzan subpoena was merely a smokescreen to conceal Jones's prior disclosure of Abel's information, the conduct at the core of Abel's claims. Abel has now subpoenaed Vanzan for documents related to the Vanzan subpoena and release of Abel's stolen information to Lively. Abel's original subpoena included 11 categories. During the meet and confer process, Abel agreed to withdraw 6 of the original requests and substantially narrowed the remaining 5 requests. Vanzan has rebuffed this overture and refused to produce any of the requested documents. Abel now seeks an order compelling the production of documents responsive to 5 of the 11 requests set forth in the subpoena. Of those 5 requests, Abel now moves to compel the following documents. 1. A copy of the Vanzan subpoena served to Jones in the SHAM Vanzan action. 2. The documents Jones produced in response to the Vanzan subpoena, a subset of subpoena requests. 3. Communications between Vanzan and Jones and or their respective counsel about the Vanzan action. 4. Documents sufficient to show Vanzan's organizational structure. And 5. Documents sufficient to identify Vanzan's shareholders. Because as we know, the company seemed inactive. They only did a furniture order in like 2019, I believe it was 2019. I don't want to misspeak, but ordered furniture in from a different country. So very strange, especially since Blake Lively only put herself as CEO on in later, just a little bit time before that. I think it was just like in December 2023 or something. I'll have to look it back, but yep, let's go. The 5 requests at issue as modified are narrowly crafted to reach documents relevant to Abel's claims that Jones misappropriated confidential and privileged information from Abel's confiscated phone and access Abel's cloud accounts to monitor Abel's activity after Abel departed from Jones in violation of the federal wiretapping statutes. The requests are also relevant to Abel's allegations that Jones relayed the data she obtained from Abel's phone to Lively prior to service of the subpoena, and that the sham Vanzan action and subpoena were devised to allow Jones to hide behind an allegedly lawful subpoena. Vanzan organizational documents and documents identifying its owners are relevant to show whether, as Abel alleges, Lively and or her proxies own or control Vanzan and were participating in a scheme for Jones to transfer the information through a sham complaint without notice to Abel or an opportunity to object. Abel more than meets the low threshold necessary to establish relevance for purpose of discovery. Then they go through a whole bunch of laws about that. Vanzan's second objection fails because there is no rule that party sources must be exhausted before calling upon third parties to produce relevant discovery. Further still, as Abel is alleging a sham scheme, it is imperative that she obtain the documents directly from both Vanzan and Jones to confirm what the actual subpoena requested, what was provided, and what communication Vanzan had with Jones about the Vanzan action. Finally, Vanzan's organization and ownership documents are not available from Jones, but only from Vanzan. For the foregoing reasons, this court should order Vanzan to comply and produce the requested documents without further objections to delay. Let's go! We want it! We want the Vanzan! We want it, okay? And they do. They put tons of exhibits. This is the very last exhibit, Exhibit E, which I thought was kind of interesting because they do show that Blake Lively's team, again, you know, they just... I'm sorry, but y'all shouldn't have said anything about this sham lawsuit because you're going to be in trouble now. You're going to be in trouble. They go in and they even put Brian Freeman's statements, you know, what Brian Freeman said, that there is nothing normal about this. Officers of the court have a duty to candor to the court and an obligation not to file fictitious lawsuits that have no basis in fact or law. Then they do put in Lively statements, and her statements are crazy, you know. The Lively parties acted upon reliable information and employed common tools such as Doe lawsuits and civil subpoenas that are entirely lawful and appropriate for pursuing claims and uncovering the identity of unknown perpetrators of unlawful activities. Then show it. Show it. What are y'all waiting for? And in every exhibit they put, the subpoena that was served, the John Does 1 through 10 from Vanzan to Stephanie Jones, which we've already looked at. Then they also put the notice of voluntary discontinuance without prejudice. So this was filed on December 19th, 2 days before Blake Lively's story in the New York Times dropped. Very interesting. Then you have Samantha J. Katz here, and she is from Blake Lively's lawyers. So please take notice that pursuant plaintiff Vanzan Inc. by the undersigned attorneys hereby discontinues this action. And we already knew that, but what's very interesting is what they say, that there is only 2 dockets in the court system. And now just by following this case and other cases that have been going on, to only have these 2 things from September to December is so strange. So you do have the summons and complaint that was processed on September 27th, 2024. It's believed that Jonesworth got it around October 1st, which kind of makes sense, the 4 days, I suppose. And then the notice of discontinuance. Nothing else. It's so shammy. It is so cray. I'm so happy they brought this up, and that judge better grant the motion to compel for this, because this, on top of what I'm already about to tell you, might just break the case open. I'm saying right now, might catch these criminals, these monsters. I think something big is about to go down this week. It's going to be messy. Y'all remember last week when I was asking, like, James Vitusca is doing a lot in the courts. Why is he removing his lawyers, getting new counsel? He did have counsel on from the Daily Mail. They were his lawyers, the Daily Mail. And then there was all of this stuff to stipulate and substitute his lawyers. I mean, he was really going for it. And I was asking, what is this going on with James Vitusca? Why is he replacing his lawyers? I was very confused. I didn't know what was going on, because you would think if you work for the Daily Mail and the Daily Mail is giving you their lawyers, That's amazing, right? Because it's like, sweet, they must be really good. They must know the amendment rights, et cetera, et cetera, et cetera, and can fight for you. But then he got rid of those lawyers and got his own lawyers, and his own lawyers allegedly are, you know, running in the same circles with Brian Freeman. Are you ready? What I'm about to say is unverified. It's coming from Without a Crystal Ball. And it kind of just makes sense when I read it. And it's going to be damning. And what she's claiming is from her sources that James Vitusca got rid of his lawyers and got new lawyers because his other lawyers made him sign an affidavit supporting Leslie Sloan and the opposing Blake Lively team under duress, under extreme duress. And now we already went over Leslie Sloan's memorandum in order to get her attorney fees paid, as well as what she used to get dismissed. And she very much used James Vitusca's affidavit, as well as him saying that he never said that Leslie Sloan said that Justin Baldoni sexually assaulted Blake Lively. Now, we already have the text that say from James to the Wayfarer camp saying Leslie Sloan is a liar. And she's told me that Justin sexually assaulted her. Why would she say that? And then he also said something like, oh, she never said anything about that. And just looking at some of the text that Leslie Sloan did say, whether or not he sexually assaulted her or not, but there are some texts that is just like, she was smearing Justin so bad, like saying, I'm telling you she's a liar. They are panicking as the whole cast hates him. I promise she's lying. This will not look good for your site. Things like that is just so bad. Here it is. The entire cast will go on record. Can you give me anything at all? She says, no, I'm on a plane. This needs to hold. Sounds good. I'd like to clear this shit up. There is a text here from Jennifer Abel talking about Leslie Sloan, how she's going to a reporter saying that they think that Bleep is speaking to Leslie to get Blake to cut this shit. I think if we can get through this, if we get the NYP piece killed and Leslie Sloan agrees to a truce, LOL. Right, because Leslie Sloan was out there in the media talking smack, smearing Justin and Wayfarer for Blake. And here's just a little text that I find very interesting from Melissa Nathan to a reporter that says, damn, this is unfair because it is also not me. Everything now looks like it's me, maybe not to you. And the reporter says, no, it totally does look like his side. Meaning that everything that was coming out was just so organic and they're going to think that it was the Wayfarer people doing it. Even the reporters probably thought that it was the Wayfarer people doing it, but it wasn't. It was just the interneting, And now just remember, James Vitusca allegedly was the one that came forward after all of this stuff dropped and called Leslie Sloan a liar and said that, that she said that Justin Baldoni sexually assaulted Blake Lively. And then Leslie Sloan was like, meh, who cares if I said that? What's the difference? Sexual assault, sexual harassment. And then all of a sudden, James Vitusca has this affidavit saying that, yeah, those were his own words. She never said that, da-da-da-da-da. Weird, bro. And if this is true and the Daily Mail is making their reporter lie to cover for Leslie Sloan, Blake Lively, and Ryan Reynolds, trouble. Blake Lively also filed a motion to continue sealing some stuff, which I think is kind of, of course, do that, but the way she's worded some of the things in here I thought was just kind of rather funny, considering like the judge already knows that. It was kind of, I think, meant for all of us, just the way it was written. But anyway, basically she's asking to have all of the parties' letters in opposition to Miss Lively's motion for protective order in Lively's amended initial disclosure, which Miss Lively designated as confidential pursuant to the protective order in place of this litigation. In an effort to protect the sensitive confidential information of third parties, many of whom may never be witnesses at trial, Miss Lively requests that Exhibit C remain under seal in its entirety. Then they go under why it should be. And then it says, Miss Lively's initial disclosure contain... Oh, I'm way up there. Sorry, guys. Miss Lively's initial disclosures contain the names and contact information for dozens of individuals who have not been subjected to discovery in this action, and who likewise may lack any substantial involvement in this litigation. For the listed individuals who are not public figures, such as members of the film's crew, the release of their names in the public may increase the risk of exposure to harassment in the press and or social media, which closely follows and reports on this action. The release of contact information for high-profile individuals additionally poses security and privacy risks. So, I mean, that will obviously be granted because, yeah, there are some things that, you know, we shouldn't be getting everyone's contact information. We shouldn't be getting everyone's info, 411, but I don't know. I think it's just kind of funny that she likes to leak other people's information, and she's fighting for all of these documents, especially even the investigation documents that has everyone that they investigated from Wayfair. Nah, she doesn't want none of her people, you know. And now we have to wait and see what's going to happen. I am so excited that Vanzan has been introduced, the SHAM lawsuit, and a motion to compel in that arena. Also, let's see what happens with James Vitusca. I need some like official sources. I need it to be, you know, let's see. But if his affidavit does get stricken because he was under duress, that is going to put a wrench in this case. I don't know what's going to happen with that. That is wild nuts. But if that is true, and James, you are standing up for yourself and you're standing up for what's right, bravo, congratulations. It's not easy, but thank you. That's it for me, but I just want to bring up this cute like little message thread from yesterday. Last night I was lying in bed and I was like, let me just go like check out YouTube, like my YouTube, and see what's happening with the video I posted. And oh my gosh, the nicest messages, guys. My heart was so full. I was smiling from like ear to ear. I was just laying there so full. I'm so amazed still by the community that we're building here of like really kind, like-minded people who obviously have different opinions and thoughts and can express that in a way, but are just here and are like, you know, happy and kind and nice. And I love that. It's something that I've always wanted. So thank you so much to these people. I mean, Helen K, thank you so much. Thomas, and then, yeah, Helen K again at the bottom was answering it. You guys literally made my day yesterday, and thank you so much. I love that I can show up here and just be myself and just have fun and try to, like, you know, do it in my type of way. And I just, oh my gosh, the way that I feel that it's resonating towards others, oh my God, I can't explain it, but thank you so much, honestly. It was the cutest. It was, oh my God. Okay, anyway, I'm like geeking out. Please allow me some grace to geek out a little bit over that because it was just so exciting. And yeah, if you have anyone that, you know, is following this case or anything about what I'm talking about, or, you know, you think maybe it could, you know, be a good thing for them, or yeah, please like, comment, and share it with other people, and subscribe. Please subscribe. I'm really, you know, I'm here, okay? So thank you so much. I hope you have the most amazing day. I'm going to now edit this video and then scoot on to work for a few hours, which is always so fun, you know, so fun. And yeah, I think I'm gonna have the best day. I'm feeling pretty good today. Just every day, you know, putting the foot in front of the other kind of thing. I feel good. I look good. I'm just like vibing. And yeah, I shall let you know how the day goes. But I hope you have the best hump day. Drop your comments. Let me know what you think about all of this. And yeah, more things to come, more announcements to come. And I'm just super excited that y'all are here and vibing with me. Okay, have the best day. Thank you so much. Love you. Bye.